Hello, good afternoon or good morning, depending on your time zone for those who are listening. As you may have seen from the flyer for this event, when you signed up last year, I already organized a couple of events on climate change and arbitration. So we now have all of our panelists, which I will introduce in a couple of minutes after a brief introduction. As you saw from the flyer, as I said, I posted two links on the flyer regarding the seminars I organized last year regarding science, the science of climate change, and how we could try to translate the science into the practice of arbitration when dealing with climate change related matters. And I think this is a really important topic to me, and I guess most people, because as long as we don't know about science and engineering, no matter what we do, and by we, I mean governments, businesses, economists, accountants, lawyers, and citizens, frankly, it's sort of like shooting in the dark. So there's no guarantee of success in what we decide to do to mitigate the effects of climate change. So I do recommend that you have a look, if you can, at least to the presentation that was made by Jean-Marc Jancovici last year, and there's a link for that in the flyer, that explains the climatology, the physics, the chemistry in relation to climate change and energy, which is, I think, a very good introduction to actually understanding science before making decisions. I'll make a couple of observations regarding the science before we get started and before I introduce our speakers. And I'm going to post right away, if that works. Wonderful. I'm going to post right away a few links to the scientific sources I have used for what I'm going to say. There's the IPCC report from the last summer, or at least not the IPCC report, just the summary for policymakers, which is 30 pages approximately. The full report is 4,000 pages. Quite honestly, I have not read it. There's also a technical summary that's about 100 pages long, that is still very digestible, I think, even for the lay person. I posted a report of the United Nations of the 17th September, talking about where we stood in terms of our targets to comply with the Paris Agreement. And basically, at that time, the IPCC said, that was in September, right before the COP26, they had said, you know, even if we meet all of the commitments we subscribed to at the time of the Paris Agreement at the COP21, our trend, our anticipated trend would be a 2.7 degree increase, so way beyond the targets of the Paris Agreement. I also attached a link to the last installment of the IPCC in March 2020. So this a couple of weeks ago, on impacts, adaptation, and vulnerability summary for policymakers. Interestingly, I think it's and maybe Lisa or Dennis or Nicolas actually will correct me if I'm wrong, but I checked quickly, but I think it's the first time actually that the IPCC mentions it in its report the word degrowth. I think it's the first time, at least according to my word search instrument. So that was quite interesting. And the link I posted is actually the summary. It's again not the full report. I posted also a link to the European Environment Agency, which is a scientific agency in charge of environment at the European Union that not that many people are familiar with, and they actually posted an interesting study about their belief as to whether full decoupling in the long run could be achieved. By decoupling, we understand having economic growth the way we understand economic growth to be defined under current standards, and at the same time a reduction on a long-lasting basis of greenhouse gases emissions. They said that it was unlikely to be able to achieve that in the long term. And again, I thought it was interesting because this comes from a scientific body, not a political or an economic body. And I posted a study on this as well from Carbon 4, which is the #1 consultancy in energy adaptation and transition matters in France. So those are, I think, all interesting because they contain quite clear scientific explanations about a lot of mechanisms about energy and climate change. Just a couple of more words more before I present our speakers on the science. What we know is that basically the society, the economy we live in owes pretty much everything to fossil fuels. Our modern economies could not have developed without fossil fuels, and in particular without oil, because those fossil fuels, they're actually food for machines, and those machines are energetic slaves that we use. On average, each human being on planet Earth has 200, the equivalent of 200 slaves, that is to say, machines powered for the overwhelming majority by fossil fuels working for them. So obviously 200 per individual is just an average. It's obviously a lot less in very poor countries, close to almost zero or very little. And it's a lot more in very wealthy countries. In some countries, it's well over 2,000 energetic slaves powered by fossil fuels through those machines we're using. So we cannot forget how much our modern world actually owes to fossil fuels, and that's why it's a hard drug, and it's very, very, very hard to get off fossil fuels, no matter what people say. Obviously, we all know the downside of fossil fuels, which is that in return for the fabulous efficiency they have, they emit greenhouse gases into the atmosphere, and the most important one being CO2, but it's not the only one. You have 6 other gases, and due to a very long-term inertia, they're going to stay in the air until they're absorbed by photosynthesis, plants or trees, or oceans, or some other carbon capture item, which presumably would be designed by human beings, but that's pretty hard to do, actually. So if we want to remain within our carbon budget to meet up the targets of the Paris Agreement, not to exceed 1.5 degrees by the end of the century. This is almost gone. There's very little chance we're able to achieve that. And even 2 degrees will be very, very difficult. As I said before, when I referred to the IPCC note of September 2021, when they said, you know, it's 2.7 if we live up to our commitments. And we also have to bear in mind that there's the issue of tipping points, which means that at a certain point, we don't really know when, we don't know how it would happen exactly, but a very small percentage point of increase in average temperature could trigger consequences that would be exponential, not linear. For instance, it could be the collapse of the tip of the upper western part of Antarctica, which will have dramatic consequences. It could be the melting of permafrost, that in addition to releasing nice viruses that have been dormant for thousands of years, like anthrax, for instance, that actually did already happen on a very localized basis in Russia a few years ago. In addition to those unpleasant events, it could also release a lot of methane into the atmosphere, which could form a feedback loop with CO2 and trigger really dangerous consequences. And when you read what many scientists are writing, at 3 degrees, it's by no means guaranteed that there would be any democratic regimes left because of the very strong climate, physical pressures, and also the geopolitical constraints and social uprisings that are most likely to result. And at 4 degrees, to give you an example, and which is a possibility, at 4 degrees, basically 1 day out of 2, you know that in most tropical areas, life would be deadly just because you would have an average temperature that would correspond to your outside body temperature. Your outside body temperature is a bit more than 35 degrees. You'd have a lot of days with that type of temperature in the air, and with a humidity level reaching close to 100%, you actually cannot evaporate transpiration, so you die. So, and obviously all of those people in the tropical areas that may be in danger are not going to wait for this to happen before taking action. So those are all scenarios that are possible and that we're all trying to avoid. And obviously one other point I wanted to make is that given the very little time frame we have to act, if we're really serious about climate change mitigation and adaptation, it would be very dangerous to bet that technological innovation will save us. It's very good to invest in innovation. It's at least as important or more important to invest into adapting societies. And a lot of engineers and scientists I talk to think, you know, as scientists, we believe like innovation will be social and political. So it's what we will decide as governments, businesses, and citizens that will have the greatest impact more than technology. Of course, a pleasant surprise can always happen with technology, but we have to be ready if it doesn't happen. And the last point I wanted to make is that no matter what we do, even if we continue business as usual and we don't really care what happens with climate change, because in the long run we're all dead anyway, at some stage we'll go on an energy diet, either because, you know, we want to mitigate the effects of climate change, or because in any event, we'll have a diminishing access to a certain number of vital natural resources that are not eternal. And also we'll have diminishing energy returns on energy invested to actually extract the energy we need. So even if we don't care about climate, we are likely to run into trouble at some stage. So today's topic is about the Paris Arbitration Week. So we have to talk about arbitration in relation to climate change and the energy transition, arbitration and investment law. Very often, as we know, there are seminars organized by NGOs and public entities that speak among themselves, and on the other side there are other webinars or seminars organized by arbitration people speaking among themselves about what should be done. And I thought it would be useful to have people from all of those different environments meeting up today to have a discussion about what can be done in our field, which is basically pretty much public international law, investment law, or arbitration. This is what all of the panelists are more or less active in. So I think it's good that we have this conversation. So before I leave the floor to our panelists, I'll briefly introduce them. Our first speaker will be Dennis van Berkel. Sorry to mispronounce, Dennis. I had the pleasure of actually sitting on a panel during the COP26 a few months ago with Dennis. I'm glad to have you back again. Dennis is legal counsel at the Urgenda Foundation, which I think if you're mildly interested in climate change, which is one of the reasons you're here, Urgenda might ring a bell in light of the major decision they've obtained against the Netherlands a few years ago in climate change. Dennis is also the director and co-founder of the Climate Litigation Network. And in his prior life, when he was still wearing ties, Dennis was a lawyer with Steve in the Netherlands, and he was also counsel with the Dutch Competition Authority. Our second speaker will be Nicolas Angelet. Nicolas is a professor of public international law, whom I know he's very focused on environmental law and climate change issues because his students are well aware of the issue in the classes that Nicolas teaches at the University of Brussels, Université Libre de Bruxelles. Nicolas is also an avocat and attorney at law at the Brussels bar, an associate tenant at Doughty Street Chambers in London, and being a member of the ICSI panel of conciliators and arbitrators, he regularly acts as arbitrator in ISDS disputes, and he was a partner with a premier law firm in Belgium before deciding to go solo. Our last speaker is Lisa Sachs. Lisa is a leading expert in sustainable development and investment law matters, to whom I have listened quite a few times during the COVID confinement periods. So at least, you know, COVID was good in that respect to the extent that before you would have had to travel to New York to go listen to Lisa, which is not only bad from a climate change perspective, but also, you know, not necessarily convenient when you have work to do on your own. So it was very useful to hear Lisa in many webinars. Lisa is inter alia the director of the Columbia Center on Sustainable Investment. I also see that prior to that, Lisa was a vice chair of the Global Agenda Council on Mining and Metals for the World Economic Forum. So I don't know if it's been a great change of scenery for Lisa. Maybe one day she'll tell us. But I think I'm going to turn over the mic to our panelists. The way it's going to work, we're going to have 3 consecutive sessions of approximately in total 30 minutes. But you know, being a Latin person, I cannot guarantee that adherence to the time limits will be strict, but I'll try. The first topic will be about will be opened by Dennis about the state court experience on climate change and EGO's experience with ISDS maybe. And this, in the second session, we'll have Nicolas telling us, you know, what we can do with the current tools, the current system in arbitration and investment law to address climate change. And the last segment will be with opened by Lisa as to whether investment treaties, ISDS should be reformed to address climate change mitigation issues, and how this could be done. And hopefully we'll have, if I'm not too bad at time management, which actually may be the case, we'll have some time for Q&As with the audience that you can post in the chat. So I'll leave Dennis open the first session on the state court experience with climate change and his perspective as an actor working with Urgenda for a few years on the current investment and arbitration system. The floor is yours, Dennis.
Thank you, Eliseo, and it's a real pleasure to be here and also to be able to talk about this this extremely important issue. I frankly think there's no, and I don't think that's, you know, it's a bit of an understatement, but there's really no more important topic to be talking about right now. And as you pointed out, I mean, listening to you, I've been working on climate change and being engaged with the topic for quite some time. And it's really the stuff of nightmares that is sometimes, if you really dive into it and you read the reports that you've posted, and there will be another IPCC report just for the people to look out on. It will be published on Monday. Basically, the first two reports outline what's the issue, what's the problem, and the problem is massive. And the report on Monday will be the newest report and these reports by the IPCC come out every 7 years. There's been one interim report, but there's a really big report on Monday being published on how do we deal with it? How can we solve this? And a bit already on what to expect. What is in that report, and referencing to what you said, Delicio. What the report will say is that if we can't wait, and technology won't save us. In short, and as you actually already outlined. There's an increasing limited space of emissions that we can still emit, because once these CO2 emissions are in the air, they stay there. So you can imagine the atmosphere as a bathtub without any hole in it. And the only way that you can prevent the bathtub from overflowing is to be on time with closing the tap, basically. And we now are at the moment that if we continue on current trajectory, if we continue current emissions, then within approximately 10 years, we will have already met the threshold where these tipping points that you also mentioned are at increasing risks of being tipped, which could cause sea meter levels within 80 years of 2 meters, which would mean that 10% of the global population and all the big capital, all the big metropoles in the world would need to be relocated. And that's just one of the unimaginable things that would happen. And that's in 10 years. And that also means that there are no real technologies that can suck that CO2 again out of the sky, except for trees at the moment, right? And we're not being great about treating, protecting nature and protecting these sort of natural lungs as they are. So the only thing that we can do, and that's what all of these models and this IPCC report, it's the largest scientific project in the world, compiling the biggest body of knowledge into one report of any, not just on climate change, but on any topic. It's the biggest scientific project. And all these scenarios show that we need to have at least half emissions in the next 10 years. So we've got actually less. So before the end of the decade, if we want to have a 50% chance of staying under 1.5 degrees, which is now seen as the critical threshold, emissions need to be halved. And that shows us that we basically need a military style directed economy where every single entity that is working in that, and that's governments and that's corporations and financial markets, their sole purpose basically needs to be, how do we do this? And everything needs to be sort of dedicated to that goal, because if we don't do that, then, well, there are lots of issues that will bite us in the tail. And that's basically sort of, in short, kind of the background in which we started this litigation in 2013. So that was, we were in a similar situation, and in many respects, the current situation is worse. But the similarities were that at that time, there was already complete consensus on the size of the catastrophe if we wouldn't act. There was complete consensus on that there was a danger level with regards to how high can we allow temperatures to rise. And at the time, the idea was that that's 2 degrees. Now we know that's actually too dangerous. It needs to be 1.5. So we have much less emissions left. And there was also complete consensus that the only way that this could be solved is that if governments commit to reducing their emissions by a certain time, by a certain amount, to close the tap with a certain pace, basically, in order to prevent this water from overflowing. And that was a reduction of 25 to 40% by 2020 compared to 1990 levels. That was a figure that came out of science, because if you know how big the bathtub is, you know how much water can still be filled, and you also kind of know, like, how should that be divided among countries. It's not too difficult to imagine that. On all of that, there was complete consensus, not only among the scientists but also on the governments, and still the governments also agreed, yes, we're not doing enough. So you think that everything is in place for real action to happen. The only problem was no action was taken. There was consensus and agreement on the insufficiency of absolutely necessary action that, if it would not be taken, would lead to catastrophic events. And this was basically the story that we brought to the court. And the only answer that the Dutch state at the time had is, yes, we know we need to do more, but we won't unless other countries also do the same thing, because it is useless if we act on our own. We can't solve climate change on our own. And this is in politics, it's a well-known argument. It doesn't matter what I do. It doesn't matter what my country do. Regardless of the size of that country, no country can solve this by itself. So let's not do anything. What we said is, well, although your current laws and energy laws and environmental laws are insufficient, given the fact that this is such a potentially catastrophic harm, there are other legal obligations that are triggered, and those are more of the fundamental human rights types of obligations and constitutional rights. Basically, the right to life and the right to family life, the right to, well, there's a whole width of fundamental rights that are being engaged by not acting on something that you need to be acting on. And that's what the court agreed with. Yes, climate change is real. Climate change is a threat to human rights. And also the court said, well, if this problem would be caused by just one entity, there would be no doubt, there would be absolutely no doubt that there would be a legal obligation on the state to act on it. So is the mere fact that there is not one causer of this problem, but there are multiple causers, there's not one, but more than one, does that take away that legal responsibility? And the court basically said, no. First of all, this is way too dangerous and important an issue for such an argument to take away that responsibility. And second of all, if we look at international law, and if we look at international environmental law, if we look at international private law, we see that there are concepts of partial responsibility, that if there are multiple tortfeasors, there is partial responsibility for the harm being done by the individual tortfeasor. And those principles we can apply to these open norms, these protective norms of human rights, which mean that the Dutch state is responsible for its own emissions and has to do at least the absolute minimum of which science says that we need to do. Well, those were two really big, you can say, legal innovations and inspirations that has caused a wave of litigation across the world, the type of cases that are now addressing government responsibility, but also corporate responsibility, even board responsibility. And it's in basic facts, I mean, the general framework is the same. And what you also now see is not only these cases are there, but for instance, specifically with regards to the responsibility of governments, you see that courts are stepping in. And why are courts stepping in? Because they see, one, well, this massive danger. They also see a completely failure of a global governance system, which should be taking care of this, but is not taking care of this. And they see that the law will need to fill the gaps that are left behind. And that kind of like, and then I'll give a couple of examples of these successes. For instance, there was a case, a judgment by the Supreme Court of Ireland, where the Irish government had produced a plan, but it was very vague. And in short, the plan said, well, we don't know how we'll do it, and there will be some technologies in the future that will save us. And the court said, well, you have absolutely no proof of that. I mean, this is a massively important, dangerous issue that needs to be taken care of well, and you're not making any plans. You're not in any way showing us how you're going to reach the targets that you say are essential for all these other issues. So go back to the drawing table and make actual plans, and do not, don't say that some technology is going to save us, basically. And there's also been a judgment in France, where the French court has said, well, it doesn't only matter what France does with regards to its 2030 target, because what actually matters is the totality of the emissions. And France had missed a couple of the intermediate targets. It had produced more in certain years than it said it should have. And the court said, well, that means you're going to overblow your target. That means that even though if you meet your target in 2030, the totality of your emissions are going to be too high to stay under the temperature level, and therefore you need to compensate. So the court ordered the French state to do more in consecutive years than they were planning to compensate and stay within this budget. A very good other example is the German Constitutional Court. The German Constitutional Court really engaged with the science, engaged with the necessity to reach zero emissions at a certain point in time in order to stay under the temperature limit, and also assessed how much that would, what that would mean for the emission space of Germany. What's the available emission space of Germany? And it had concluded that if Germany would continue to emit according to its climate act and its climate target, which was a 55% reduction by 2030, which is the same target as the EU, which is not irrelevant, then the entire budget available for Germany would be depleted by 2030. And even, even in the court, the court then concluded, well, that implies that you're planning to stop emissions from one day to the other, which would basically, sort of mean that everybody needs to live in a tent in a forest and start hunting rabbits, but that they can't emit anything anymore, which would be an unimaginable restriction of freedoms. So there the court said, no, the German climate law is unconstitutional. The government needs to go back to the drawing board, look at the science and make real and consistent plan and create a functioning framework in which you're going to make sure that those emissions are going to go down. This has happened in the state space. It's now also flowing over into the corporate space, and a very good example of this is the case against Shell, also in the Netherlands, where basically the same facts were presented, and there were a lot of similarities. Shell also acknowledged that climate change was a problem. They actually committed to a zero emission net zero by 2050 target, but they didn't really have the policies in place to actually reach that, and also on the short term, they didn't have the targets. So that's in 2030 that actually make sure that you stay within the global budget. So they only had a far in the future a target with some vague plans which weren't concrete enough. And the defense of Shell there was, well, the plaintiff said, well, you also have your own responsibility. You have your human rights responsibilities. And the plaintiffs there, Shell, used what is also known sort of as in other spheres as a drug dealer defense, which was very similar to what the Dutch state did. But they said, well, it doesn't really matter what I do, because if I don't sell my product, someone else will sell the product, right? If one drug dealer gets arrested, another drug dealer will sell it. So, and there again, the court didn't agree. They said Shell is a corporation with an enormous span, an enormous size of emissions. It has its own responsibility with regards to emission reductions. What needs to happen on a global level is this halving of emissions in the next 20 years. And that's the norm that I'm going to apply to Shell as well. With regards to your own emissions, that is an obligation of result. And with regards to the emissions of your suppliers and your customers, that's an obligation on effort. So here you see courts basically stepping in to fill these gaps in thus far still a failing global governance system. And I think that it's inevitable that you'll see that more and more. And kind of like the conclusion of that is that also for corporations and for lawyers and governments, you need to expect the goalposts to be shifting. If you are only focusing on narrow current legal obligations within specific jurisdictions, you're missing the fact that there's this other sphere of rights, more fundamental rights, and ways that courts are now finding to enforce obligations and to basically say to all the players involved, both governments and corporations, you know what needs to happen. You know the science, you know the urgency. So you can't say like, well, as long as I abide by kind of like the more narrow domestic responsibilities that I have, as long as I'm not forced by the government to do one or the other, I'm fine. That kind of like wisdom is no longer applicable.
Great, thank you, Dennis. And it's just among the recent lawsuits, you've probably seen this as well. In the last few days, I think Client Earth bought a few shares of Shell, and they filed a lawsuit not as an NGO, as a charity, but in their capacity of shareholders against the members of the board of directors of Shell, saying that their actions or their lack of actions, allegedly, according to Client Earth, would in the long run, in any event, affect shareholder value negatively if they didn't take proper action. So I think that started a few days ago. I don't know if it's the first time it's been done that actually by way of a shareholder suit against the board of directors itself, i.e. individuals, not just corporations. So that's an interesting development. I wanted to
on that, Eliseo, it's not the first time that Client Earth has done this. The first time they did this, it was in Poland.
Okay.
And against Enea, a large coal-fired power plant owner, and they won that case. So it has already it is a legal argument and a strategy that has worked. There they also bought a couple of shares of this large coal factory, and they said, well, you're basically you're hurting our financial interests by investing in a coal plant that nobody needs.
Good to know that. That way it's good that the arbitration guys like me hear guys like you. We all learn from each other. One thing I'm interested in hearing is, because I'm assuming you've got quite a bit of an experience with amicus curiae in investment arbitrations as well, and a couple of a month ago, approximately, there was a famous case, Odyssey versus Mexico, in which the majority of the tribunal, it was an environmental case in an investment arbitration. The majority of the tribunal decided not to allow an amicus curiae with a dissent that was published by Professor Philip Sands. So I think in the arbitration community, this is something that has been quite widely circulated. I think it was about 2 months ago. And I guess you've had yourself, Dennis, your own experience with the amicus curiae. I don't know if you can give us some outlook on this.
Yeah. Yeah, thanks, Eliseo. I didn't, when I started this climate case, I didn't expect myself to be veered into kind of like the arbitration field, but that was in response or a necessity of the fact that arbitration suits are now being launched in the Netherlands against the very measures that are aimed at implementing our Urgenda judgment. So a bit of bigger background on this. After our judgment, the government, and I think it's a very good example of how, at least at the moment, of two things: how arbitration is a massive impediment to the measures that need to be taken, and how arbitration is also rapidly losing legitimacy, at least in the Netherlands and also in a number of other countries that face similar problems. The problem here being that after our judgment, the Dutch government passed legislation closing all coal-fired power plants by 2030. And that's not illogical, because that's what all the models tell us is necessary in order to stay under 1.5 degrees. And RWE and Uniper, two owners of coal-fired power plants, launched arbitration suits against that closure date. After this, it became clear that more measures needed to be adopted in order to stay under the level that the Dutch Supreme Court had ordered is necessary, is the necessary reduction level. So in other words, more coal-fired capacity needed to be closed quicker. And now a law has passed that basically caps the remaining coal-fired power plants at a certain level, and there have been negotiations to close another coal-fired power plant, and these are very new coal-fired power plants. They only opened in 2015 and 2016. But what you see surrounding these surrounding these negotiations and the adoption of the law is that the government wants to do much more, but you can see that they feel very basically threatened by already having arbitration suits launched against them, and great difficulties for the current Dutch government in how do we actually comply with the Urgenda judgment, given the threat of these arbitration suits that are already there, and what if we do even more than that, what will happen? And this is the context against with what you were referring to, Alicio, is that we have also, we indicated to the tribunal in these two cases of RWE and Uniper that we think it is important for us to be able to present our views in that case, specifically with regards to the impacts of this judgment on the the extent to which the Dutch government is actually able to protect their human rights or to comply with their human rights obligations in the Netherlands. So we've made this known, and we're not at the stage in these proceedings yet where we're actually able to submit, or where we've been allowed to submit these the amicus curiae, but the case that you refer to, obviously, as we've seen it as well, and we were rather disappointed. And I think that the experience that we are currently having in the Netherlands, I mean, and the background that I sketched is really leading to in Parliament and in the government itself to a rapid losing of legitimacy of the arbitration process, where people are discussing, well, we need to get rid of this energy charter treaty because it just doesn't work. We can't do the proper climate policies that we need with this energy charter treaty. So I think there are really big questions that need to be answered by the arbitration community on how to deal with this.
Thank you, Dennis. We're pretty much on time. I have a couple of observations, and I guess this will be developed later also by possibly by Nicolas, who present the view of what can be done with the current tools. So sometimes, and I think this is one of the difficulties we have, because I'm quoting you, Dennis, arbitration is a massive impediment to taking the appropriate policies against climate change. And arbitration, it's a tool, it's not substantive law. So the tool is what you do with it. So how much, and this is a debate we're not going to be able to solve today, but how much is due to the system itself or the way it is used, because it's a tool. And when you look at the criteria for allowing amicus curiae, whether it's under the exit rules, under the incitral rules, or when you look at the criteria that apply, and I won't go through them because we have to comply with time. It doesn't seem that it's such a high threshold to be crossed when the submission, the amicus curiae submission, is relevant to the dispute, especially if it can bring an insight that apparently has not been presented by the parties. So when I view the criteria, and maybe Lisa has a different view, but I don't view the criteria as inherently wrong and inappropriate. It seems to me that they should allow as a tool in practice for relevant amicus curiae, and then whether it's the way it's practiced, does that make a difference? The other comment I wanted to make very quickly, and that's one of the problems, I guess, also for a lot of investors as well, but also I believe as a citizen myself, is that governments themselves, possibly because there's always an election around the corner, and that's the way democracy works. We have elections, and we have elections quite often. So they very often take on inconsistent positions and contradictory policies. And you've seen that in many countries in Europe. where they'll say one thing about what should be done to mitigate climate change, for instance, and very often, very quickly, something inconsistent will be done. And I think it's a very difficult framework. I see the Netherlands, for instance. I don't know what the tradition is in the Netherlands, whether it's an anti-nuclear country, but I understand they're launching 2 nuclear power points, or they plan to do that shortly, so that policy also changes quickly in view of the constraints, and governments don't really have a plan, it seems. And the fact they don't have a plan is also a problem for investors who don't know where to stand. And somewhere, I agree, at the end of the day, I have children, and I want to be able to look, if I want to have grandchildren, and I want to be able to look at them in the eye. But I think sometimes I wonder how much is a practice, how much is the default of the system. I think we can tackle this a bit more later on in the successive presentations with Nicolas and Lisa. I don't know if the two of you want to add something at this moment before I hand it over to Nicolas. Okay, so Nicolas can take it over to explain how the current system of investment laws and ISDS can operate in a way that we can address climate change, not just as a way of the business of the energy transition disputes, which is obviously a very good business for the arbitration community. There's no denying that, but how we can use those tools not to be a massive impediment, if we use the words of Dennis. The floor is yours, Nicolas.
Thank you very much, dear Eliseo, and thank you for inviting me together with Dennis and Lisa to this very interesting debate. So I will indeed argue that adequate measures to combat climate change can be taken under the current system of international investment protection, and that we must not wait for a new international regime to come into being. An important factor by way of background is that the international legal system largely focuses on stability, to the detriment of that other function of every legal order, which is to organize timely adaptation to new challenges. And this is a general feature of international law. It is focused on stability, and as it happens, international investment law adds an additional layer to that stability-oriented approach. And therefore, adapting or terminating the international investment regime is a difficult task. Yet climate change is obviously an urgent issue, and we must therefore consider how to address climate change under the current investment regime. Now, my point is that the law as it stands is appropriate to deal at least with the most delicate aspect of the relationship between investment law and climate change, which is the one mentioned by Dennis, namely that the investment regime must not stand in the way of measures to combat climate change and its consequences. Investment law must do no harm. And I think that's correctly interpreted and applied, it does no wrong. I will illustrate this by reference to substantive norms, methods for reacting to change, and reparation. First, substantive norms. It is established beyond dispute today that states are not liable to pay compensation to a foreign investor when, in the exercise of their regulatory powers, they adopt bona fide regulations that are aimed at the general welfare, that are non-discriminatory and not manifestly disproportionate. Obviously, our arbitral review of proportionality may be a delicate issue, at least for some types of regulatory measures, but I think it should not be an issue for climate change measures. Scientific evidence abounds that humanity is running terribly late on climate change, and I think we are all convinced that leaving all other issues and all other impacts aside, even putting an end to all fossil fuel activities today would not be disproportionate from the perspective of the fight against climate change. But the question is, of course, can arbitral tribunals be trusted to make these findings? The answer, I think, is that state parties to investment treaties can and should adopt interpretative declarations of their treaty commitments, setting out these points for greater certainty, setting out some established facts regarding climate change. Facts regarding climate change are officially acknowledged by the international community, setting out the consequences of climate change, which are also officially acknowledged, and then set out how they impact on the application of international investment law under a given treaty. This, I suggest, is a rather fast and efficient method to make sure that the law as it stands will be properly applied by investment tribunals. Now, moving to the second point, rules of international law that allow for reacting to important changes. Let me say a few words on the circumstance precluding wrongfulness called state of necessity. State of necessity allows states to derogate from their international obligations if this is the only way to safeguard an essential interest against a grave and imminent peril. Now, this seems particularly apposite where climate change is at stake. However, the articles on state responsibility, which is one of the main documents referred to by almost all investment arbitration tribunals, the articles on state responsibility specify that a state may not invoke necessity if the state itself has contributed to the state of necessity. Now, of course, all states have contributed to climate change. And the question is, does that mean that this legal figure is inoperative with respect to climate change, the most grave and imminent peril of all? I don't think it does. There are several reasons for this, but the essential reason appears when one considers the purpose of that condition of non-contribution by the state invoking state of necessity. That purpose is reflected in the maxim that a man may not benefit from his own wrongs. Nemo auditur suam turpitudinem allegans, as it goes in Roman. In line with this, only intentional or at least conscious contributions to the situation of necessity would be of relevance. And yet we know how long the concrete consequences of climate change have remained either unknown or at least hidden in humanity's subconscious. Perhaps more importantly, and also in line with the purpose I just mentioned, the function of the condition of non-contribution is to prevent the state from shifting the burden of the protection of its own interests on an innocent third party. That is a point made by the International Law Commission on a related issue on circumstances precluding wrongfulness. You can't shift the burden of the protection of your own interests on an innocent third party. Now, in this light, a state that contributed to climate change in a relevant manner may still rely on the state of necessity as against an investor in the fossil energy sector, which is in the same position in terms of contribution and knowledge as the state itself. In terms of legal maxims, we then move from nemo auditur to, I apologize, in pari causa, which is the other maxim, which renders nemo auditur inoperative when both parties have done wrong. So the condition of non-contribution does not stand in the way of invoking the state of necessity to justify or to further justify climate change measures from the viewpoint of international investment. Another point regarding the state of necessity, which is sometimes misunderstood, is the following. It is often asserted that the existence of a circumstance precluding wrongfulness does not preclude compensation, and that is stated as if there were a basis under international law to claim compensation, the circumstance precluding wrongfulness notwithstanding. In fact, Article 27 of the ILC Articles on State Responsibility provides more specifically that the circumstances precluding wrongfulness, and I quote, are without prejudice to the question of compensation for any material loss. Without prejudice to the question. This provision does not, unlike what arbitral awards have suggested or stated, this provision does not state that the state relying on the circumstance precluding wrongfulness is not dispensed from making reparation. The provision leaves the question of compensation open. The question is therefore simply not regulated under the law of state responsibility. And indeed, the commentaries of the International Law Commission state, I quote, that it will be for the state invoking a circumstance precluding wrongfulness to agree with any affected states on the possibility and extent of compensation available in a given case. It follows that, unlike what is assumed in arbitral awards, no compensation is due under international law. Therefore, it cannot be accorded by investment arbitration tribunals, lest they have powers to decide ex equo et bono. So that we could discuss other aspects of the state of necessity, but basically the two major hurdles can easily be overwon. The state of necessity can be relied upon to justify climate change measures as against the background of international investment law. Now, at this stage, I'm bound to admit that my argument consists in saying that international investment law is fit for purpose because its application can be rendered inapplicable on the basis of circumstances precluding wrongfulness. But even so, the condition is satisfied. My third point is concerned with reparation. And then perhaps first, as a brief point of background. I think the essential point is that it should not be lightly assumed that the investor will obtain full compensation of all its losses. And then by way of background, as I said, it may be useful first to recall the functions of reparation, something I think international investment lawyers rarely reflect upon. And in fact, the functions of reparation vary beyond the basic function of compensation. Reparation for a blatant miscarriage of justice, for instance, has a preventive function. By contrast, the decision whether to grant or deny compensation for the consequences of a bona fide climate change measure cannot have a preventive function. We do not want to prevent states from acting against climate change. The function of compensation, of reparation, can certainly not be to prevent states from acting against climate change. In this case, therefore, the question of reparation, I submit, is one of the allocation of the financial burden of regulatory measures. The question is, who is going to pay the bill? And the investor who brings a claim, in fact, argues, I'm not going to pay this bill. Now, when we discuss climate change, this question of allocation of the financial burden arises, as we have seen, in a context where the whole of society, and indeed the whole of humanity, is going to bear an enormous burden. And then I submit that it would be surprising, and even more so, it would go against the principles of fairness, coherence, and responsibility that are core to international investment law if investors in the fossil energy sector were granted compensation in a way that would in fact dispense them from participating in that burden sharing. It would be surprising if the only actors on the field who would escape contributing to that massive effort would be those who are granted compensation because they have brought an investment arbitration case relating to the fossil fuel sector. So that's the background. Now, if we move to more concrete issues, I have a number of additional points, and I will stop with this. There are a series of reasons why investors may not obtain full compensation for their losses. First, as we all know, according to the international law of causation, victims of a wrongful act cannot obtain reparation for damages they would have sustained in any event, absent the wrongful act. Concretely, this means that a fossil energy producer whose plant is shut down to combat climate change, as Dennis just mentioned, will not obtain damages insofar as his future profits would have decreased in any event due to the competition from green energy. And that is not to mention losses the investor could sustain because of climate change itself. That's the first point. Second, where an investor in the energy sector is concerned, contributory negligence may also significantly reduce the damages. As experts in their field, these investors are very well informed of climate change and of the urgent action required. To that extent, they invest also at their own risk. And third, victims are required under the general principle of law and of international law to mitigate their losses. This is relevant where the host state, as Netherlands does, offers accompanying measures to assist an investor in transiting to less polluting production modes. Such measures are, I submit, a way to orient compensation towards greener energy transition. Either the investor accepts the help of the host state in doing the transition, or his damages will be reduced because he will have refused to mitigate his losses. And you may note here, there is perhaps something good about international investment law for climate change. You may note that the existence of the obligation to mitigate and its impact on a potential reparation claim, in fact, functions as an incentive for states to invest in energy transition measures. So this is the brief overview of how I see international law and international investment law as it stands with respect to international measures taken to combat climate change and its consequences. And basically my conclusion is that what we need is a thorough interpretation and application of all relevant principles of international law as it currently stands. And this can be done by arbitrations. As Dennis mentioned, courts are stepping in, and what we must expect is that arbitral tribunals will come to the same conclusions and will and certainly should step in as well. Thank you very much.
Thank you, Nicolas. I don't know, Dennis, Lisa, if you have comments on this, we can take a few minutes. We're surprisingly on schedule, so you may comment.
Yeah, Lisa, I have a couple of thoughts, but I'm happy for you to go first if you wanted to share something as well.
Sure, thank you. And I'll use this as an opportunity to thank you, Eliseo, for including me in this discussion. All of my conversations with you have been enlightening, and it's great that you connected me with Dennis and Nicolas. It's been wonderful learning before and during this discussion. Maybe just one reaction, although as you can imagine, I have many, but Nicolas has pointed to a number of principles of customary international law or international law that the assumption is that they would be applied. But of course, the way that customary international law or international law principles are applied or have been disregarded in investor-state dispute settlement is at the root of the widespread and mounting criticism of the system and of recent awards, and that shouldn't be overlooked. There are many cases in which, for instance, explicit treaty exceptions are disregarded by tribunals, that tribunals don't even overlook or don't even look at explicit police power provisions, that joint interpretations by the member parties are completely disregarded. For instance, most recently in Eco Oro v. Colombia, Canada and Colombia put forward joint interpretations that went to your other point, that they view an exception as that states retain significant policy space under their investment treaties to regulate in the public interest, and the tribunal discounted their input and found Colombia liable under that treaty despite joint interpretations. Eliseo had suggested that that there are no barriers. Well, in practice, there are tremendous barriers to amicus being accepted, never mind accounted for, with limited effect that they may even have. But there are a number of critically important cases with major public interest considerations in which amicus have been denied. Ours was denied in Bear Creek. There were 5 civil society NGOs with an interest and with important perspectives in Eco Oro that were disregarded. Very recently, the Center for International Environmental Law and a local partner filed an amicus in the Odyssey Marine Exploration case, wanting to raise important factual and legal elements about the environmental and social and economic risks that the project represents for the community, and that was denied. So just wanted to point out that some of you're pointing to some of the features of the system that are meant to protect the public interest, protect the rights of states, protect the rights of other third parties, and so on. But it is precisely how those have been disregarded that is at least among the concerns about the system.
I'll just interrupt 1 second before I let you debate further, but hearing what Lisa says, in your view, is that and I know you have systemic issues as well, but what is the part that is played by the personnel, I mean, the arbitrators and the level of specialty they may have, because it seems to me that maybe some people are extremely focused on investment law, but even the many BATs, and not just the modern BATs, but the Energy Charter Treaty, for instance, at Article 26.6 refers to the fact that to decide the dispute, the tribunal must apply not only the treaty, the ECT, the Energy Charter Treaty, but also applicable rules and principles of international law, which now include the Paris Agreement, the Glasgow Climate Pact, EU climate law that evolves rapidly, and the national and soon the nationally determined contributions pursuant to the Paris Agreement. You have got also the principle of systemic integration under Article 31, 3C of the Vienna Convention on the Law of Treaties, that also requires that tribunals take into account the relevant rules of international law. So it seems to me, and I haven't said this because I haven't introduced myself, in practice, I'm a commercial arbitration person. I act very often as a commercial arbitrator, do lots of ICC arbitration, other institutions. So I have the curiosity of almost of a neophyte. So, but when I look at those provisions I mentioned in the ECT, when I looked at the Vienna Convention and the systemic integration principle, it seems there's a lot of tools that you can incorporate so that investment law can interrelate, interconnect, and dialogue with international environment policy, for instance. And is it a question that it's not properly used because we got the wrong personnel, the wrong training, too many people that are too specialized? Do you have a view on this? And then I'll let also Dennis and Nicolas react before we move on.
Let me try to be brief on this point. I think the nature of many of the interpretations are problematic, if not shocking, in some cases.
I'm sorry, can you repeat what you just said, because I didn't hear the
I think that the nature of the interpretation.
If I may, it's when you put your hand on your
mic.
Sorry.
Sorry about that. I'll put my hand behind my back. For sure, I think the interpretations are a part of the challenge. I'll reserve for my longer remarks that I would certainly not stop there in terms of my concerns, but I think that's part. There was a recent paper, which I'm sure everyone on this call has seen or may be interested in, by the Climate Council, looking at recent jurisprudence, the investor state arbitration jurisprudence of the Energy Charter Treaty in cases related to fossil fuels. And they specifically look at this question. I mean, every treaty says that applicable international law can and should be applied. That's not unique in certain cases. And their finding was that in the extremely limited case that international law outside of treaty law was applied, it was in maybe one or two cases, and just looking at EU law. Never reference to any other aspects of human rights, Paris Agreement, God forbid, or any other relevant areas of international law. So I think that, of course, the Vienna Treaty and these treaty provisions suggest, encourage it, require it, and so on. So that would help. There are also cases in which countries like Romania, in one case, was held liable by the European Court of Human Rights for failing to protect their citizens from cyanide poisoning from a mining project. Now, in a different mining project, a mining project is suing Romania for failing to give them the license to let them mine when the concern is about cyanide poisoning. Okay, there's not great integration. Could that be resolved by different arbitrators, with more familiarity of these different areas of law? Maybe. I don't think the lack of familiarity or the lack of integration helps. But I guess, as I'll get to, I don't think that's I don't think that would solve our problems.
And then I'll shut up afterwards, but I just want to rebound on what you just said. It seems to me rather odd that that in fact some tools exist, even if they're flawed, as you just said, and you have a more systemic problem with how to deal with this. But seen from the outside, almost, it seems that, and maybe it's also due to the fact that a lot of those ECT awards that you refer to in the Climate Change Council study, they were, rendered some time ago, and it's only the last few years really that the public pressure, even if we were well aware of the problem, the public pressure on climate change has really risen lately, very recently. So I'm not surprised that the arguments were not raised. But the fact is, the claimants don't raise them, the respondents, the states don't raise them, the arbitrators don't raise them ex officio. Nobody raises anything. There seems to be something wrong under the way we use the current system, because we all talk about, I mentioned those systemic integration principles. We talked about the personnel, but who's doing the arguments? The counsel for claimant, counsel for the respondent, the state, the arbitrators who may raise issues ex officio if they think they're relevant to deciding on a claim. There seems to me that there may be an issue with the practice itself before we turn to the system, as will be discussed with Lisa. Just my 2 cents. I let now Dennis and Nicolas add anything they want to add, because I've said too much already, I think.
No, I think a couple of reflections. I mean, current. I think in many respects, Nicolas, I find your presentation encouraging in the sense that this, there is a way that you might be able to use these tools in a way that would actually be, serving society at large. I mean, at least from where I'm standing, the current practice is the exact opposite, which at the moment leads to the conclusion that we have tools that can be massively damaging, that are being used by the entities that have the capabilities of using those tools, and that's a very small group of society which has already a lot of power in many respects. I mean, the democratic legitimacy of this system is nowhere to be found, and they're being used in a massively damaging way. So I guess that is a fundamental problem, and whether that system, I think, will survive will to a large extent also then depend on the responsibility that these actors, this very limited group of people, to the extent that they're listening to you, Nicolas, and think like, okay, we actually do have to use this in a different way, and because I don't see this system otherwise surviving in the long term, and then it will be a question of how much damage will it have done until we reach that moment. I mean, that's frankly from from the position where we are at, and what I and what I can see at the moment. And I think and maybe one comment which is a bit more in response to more specific to what you've said, Nicolas, and also you, Alicia, what you said, like, well, it seems that governments, sometimes don't know what they want to do. And obviously, I mean, for politics, climate change is and has been a massively difficult problem. The same corporations launching these cases have really, to a great extent, contributed to the complexity of the problem. Let's not forget this. They're not innocent in this. And I think that also speaks to the fact, like, what can these corporations now expect with regards to that government policy? And that's what I also meant with like looking at the narrow policy and looking at the broader policy. I think we should all expect that the goal of all governments, even though they might not have implemented the policies, but the goal of society and governments at large, just look at the climate Paris Agreement. It's there. All governments are party to it. We need to hold temperatures below 1.5 degrees, full stop. And the rest is just, okay, common sense, and look at the science. And if your business, if your business plan doesn't fit the science, then you can't have any legitimate expectation that what you are doing is okay, and that you can have some expectation of still making profits over those economic activities.
Thank you. Yes. Well, in a sense, obviously, it's not that I disagree with you. The point I wanted to make is that the law can be used in a manner that does not damage the fight against climate change. That is my point. And I think it's an important point to make because it's the first step to trying to obtain better applications as long as the system stands. So that is the first point. Now, the real question, of course, then is, oh yes, and perhaps on a rather technical issue, two technical issues. The first one, Lisa, you were right in mentioning that Canada intervened in the Eco-Euro case in support of Colombia, but that was technically, that is not quite the same level as a joint declaration interpreting an existing agreement. The legal value is not quite the same from an international law perspective. That's the first point. The second point, I'm not defending Eco-Euro because when I made the point that tribunals tend to believe that compensation can be granted by a tribunal, even in the face of a circumstance precluding wrongfulness, that is Eco-Euro, which stated that and which is wrong. So the question is indeed how can this be improved? My starting point, as obviously as a litigator and an arbitrator, is that I've been before many courts, and arbitration has its defaults, but we should not believe that domestic courts always get it right. That is not the case, unfortunately. And many domestic courts may be very inimical to their own state. So that's one point. And the second point is that we do need settlement of disputes of one sort or the other, right? We're not going to abandon access to justice. And so, well, the question is then, is arbitration really problematic intrinsically? And if so, why is that the case? I think it is to some extent an issue of prise de conscience, of awareness, I believe. Many arbitrators come from the business world, which in all sectors is reacting very slowly to the challenges of climate change, right? You have arbitrators deciding Uniper. I do not know them, so I'm certainly not criticizing them. You have lawyers defending Uniper. And you also have Uniper people who think that it is legitimate for them to bring claim. So the problem is not specific to the arbitration mechanism. It is the whole of society that plays the game. And I think you won't stop the game by just abandoning arbitration and replacing with access to courts, to domestic courts. Huge, enormous claims can be brought in domestic courts as well, right? So I think it is really a matter of raising awareness and of inciting investors, counsel, and arbitrators to consider this issue more thoroughly, rather than to follow the traditional approaches prone to considering, in fact, that is the problem, that economy prevails over either the environment or human rights, etc. That is the important point. And I really think it is a matter of raising awareness.
Unless there's any more comments, we're going to move on to the next session. Just maybe a brief comment for me, and this is actually one of the problems, is that because people don't know the science, including political leaders and economists, we tend to forget some basic, very basic elements, which is basically that the economy is just the system of extraction and transformation of natural resources through energy. It's nothing else. And the economy does not factor the fact that Mother Nature is giving us all of those natural resources for free. Oil is actually free. When you never pay for oil, you pay for the royalties to the people who happen to be sitting on top of the oil, and you pay the people who are extracting the oil. But the oil itself was given for free by nature, just like the air we breathe. Except that a lot of those natural resources, including the oil itself and iron as well, or on the scale of a human civilization at least, or limited and declining at some stage. Yet, at nowhere in the economic model is this problematic really factored, which is a problem to be tackled by governments and then by all of us who apply the law and do litigation. And I'm very surprised not to see that debate yet, in particular in energy transition cases. And maybe if we have time, we can say a few words about this later on. But we'll move on so that I'll just recall additionally that I think every government should have, as respondent in an exit arbitration, should probably hire Nicolas as its lead counsel, apparently, because nobody else is making those arguments. So you make sure you publicize the YouTube link I'll be sending at the end, Nicolas, you never know. So now, Lisa, it's your turn to not to answer the question whether the system should be reformed. I understand it would be more than that on your side.
Yeah, thank you. Again, first, I just have to smile at the suggestion of raising awareness, because as you may also know, one way that quote unquote awareness is being raised about this is that law firms are advising companies of the opportunity to use ISDS to fight climate measures. So let me quote, I'm going to abbreviate the quote, but without changing the meaning. One firm just issued advisory, quote, climate change litigation is an opportunity for companies exposed to certain climate-related government measures to vindicate their rights. Companies and industries most affected by states' climate change obligations, example, fossil fuels, mining, et cetera, should audit their corporate structure and change it if needed to ensure they are protected by an investment treaty. It is important to assess which treaty would best protect the company from any adverse climate-related government measures. So I trust this is not the type of awareness raising you're talking about, but it's what's happening. So let's be mindful about that. I know I was brought on to share my quite different perspective. There are a lot of suggestions of how the system might be reformed from within, including the helpful reminders and suggestions from Nicolas that make sense if states start from two twin premises. First, that traditional treaties and the arbitration mechanism within them are serving broader societal interests. And the second, that the shortcomings that we are seeking to address of ISDS relate mainly to states challenging or to states' climate change measures and to the risk of challenges to the climate-related measures. I'll come back to those, but I'd like to start from a very different premise. And I'm reminded in the discussion of the parable of the blindfolded people feeling the elephant and how deeply perspective and, in our case, objectives matter when deciphering a problem and proposing a solution. I start from the perspective of how law and dispute settlement, because Nicolas is absolutely right that dispute settlement plays a critical role, can and should help states address the climate crisis. States need trillions of dollars of investment to achieve climate mitigation and adaptation goals, investment in renewable power generation, transmission, storage, and batteries, and green hydrogen, electric transportation, energy efficiency, in climate adaptation measures. By the way, states also need trillions of dollars of investment to achieve other critical sustainable development goals. Climate is critical, but so too are other sustainable development goals of poverty reduction, improved health outcomes, education, food security, access to water and sewage systems, public infrastructure. States are facing an investment gap of trillions of dollars per year in order to achieve the Sustainable Development Goals, including the energy transition. On that, I think we can agree. I am not anti-investment. In fact, I'm trying to mobilize investment to the right areas. Globally, we have another urgent climate-related objective, which is to stay within our global carbon budget and to avoid catastrophic, cataclysmic, and irreversible climate change. And one of the imperatives of this is to categorically stop all new fossil fuel projects, stop building fossil fuel related infrastructure, and to progressively phase out fossil fuel projects. We have more known reserves today than we can safely burn. This has been repeatedly established by the IPCC, by the International Energy Agency, including in their report last year that stressed that we have no room in our carbon budget for new fossil fuel expansion. States, of course, have committed to the Paris Agreement, which incorporates the science and its implications. So to my mind, these are our two global objectives: financing sustainable development, including the investments needed for the energy transition, and phasing out fossil fuel extraction infrastructure. So the perspective from which I come to these critical challenges is the following: what role can and does law and governance, including dispute settlement, play in achieving these two objectives? How can law help to achieve these two goals of mass decarbonization and of a mass scale up of universal, affordable, accessible, clean energy? What aspects of that governance framework should be at the domestic level? What role can and should international law play? Those are the questions that I ask. Investment treaties, as currently conceived, including every new quote unquote new generation treaty that is currently, that has been or is being negotiated, are based on two premises: that legal stability, as Nicolas put it, or that international protections, because it's not just stability, but other types of protections and privileges for foreign investors will stimulate or accelerate these investment flows, and that those investment flows will help states achieve their sustainable development goals. That's the premise of our current international governance system, among other objectives that one might add about contributing to rule of law and depoliticizing disputes, which I can always get into, but for the sake of time, I won't. We are a few decades now into this, the evolution of and growth of this treaty-based system. And we now know both of these assumptions or these premises to be deeply flawed. And that's problematic for two reasons. We are investing in a system that has not proven to be effective at its aims and has come at substantial cost, which I'll come back to. And the other reason that it's problematic is that by staying so focused within this system, we are distracted from fundamentally rethinking national and international investment governance, which is our shared interest, and how it could be redesigned to serve its intended purpose of mobilizing and governing investment for sustainable development. I edited a volume in 2008 looking at whether investment treaties mobilize foreign direct investment. At that time, we summarized over a dozen papers, empirical analyses looking at that. There have been at least a dozen more in the past dozen years. Those multi-dozen empirical analyses have failed to conclusively demonstrate that investment treaties stimulate or promote investment flows. Undoubtedly, the treaties influence how investments are structured. I just gave an example of why. Counsel is advising it, but there's no conclusive evidence that investment treaties have increased investment flows among treaty partners. We know it to be the case that not all investment contributes to sustainable development, and in fact, some contribute substantial harms. My center, CCSI, and the OECD each wrote reports in 2018 that meticulously documented the substantial and varied costs of the system, which go far beyond the risk of regulatory chill or having to pay for measures related to climate action, for instance, even though that's the focus of our discussion today, against the wholly uncertain benefits. So the climate-related issues we're discussing today, and we haven't even gotten into some of the real risks, although we have to some extent, and there are excellent papers by IASD, IIED. There's well-documented potential to chill climate action or to transfer the costs of stranding assets to citizens, to the moral hazard of continuing to enable or allow reckless investments in fossil fuels are far from the only problems with the system, though, as I think we're saying today, even on their own, even if they were the only problems, it would be enough for a fundamental rethink given the crisis that we're facing. But solutions that focus only on how to avoid these consequences, however major these consequences are for climate, because they are, ignore the many other substantial costs that are not resolved by these proposals, never mind the even more basic fact that these costs outweigh any uncertain benefits. So in our view at CCSI, and I know I share it with many others who are fighting quite hard for the success of our societies, from a climate perspective and from a decency perspective, I think it's irresponsible with respect to present and future generations to keep in place a knowingly flawed regime with unknown benefits and with great known costs in the hopes that tweaking it at the margins will cause necessary fundamental change. I do want to be clear with this community, and as Nicolas said, that dispute prevention and management and resolution are fundamental to functioning legal systems, and they are critically important considerations to the design of domestic and international governance mechanisms. There is a critical role for lawyers. There will always be a critical role for lawyers and those specializing in dispute prevention and resolution and resolving the many challenges that are bound to arise when we're looking to mobilize trillions of dollars per year in investment and facing these huge challenges. But I really urge us, because I'm one of them, this community, to approach these challenges in a more thoughtful way and to start from our shared goals for decent, safe, harmonious, and livable societies, including a livable climate. And then approach the question that our particular sector is interested in, which is the role of investment and the role of law and governance in achieving those aims and in shaping investment to align with those goals. So what role does investment play in achieving those goals? Where does it need to be accelerated? And where does it urgently need to be phased out or shifted? And in terms of the new investments, what are the constraints? In terms of the phase out, what are the constraints? We're working on these questions at CCSI because they're critically important questions. I can say with confidence that the availability of international legal privileges and protections is not among the top drivers of necessary investment. There are other decisive aspects of financing, guarantees, markets, policy roadmaps, public grids and infrastructure, clarity over domestic regulatory processes, another role for lawyers, and so on. So let us think critically of the role that international and governance can and should play in addressing those constraints and in bolstering domestic systems and institutions, including their capacity to handle disputes as they arise, because domestic systems still handle the vast majority of disputes and will continue to. So what a wonderful and urgent challenge for all of us to take on. I really believe it's so important for lawyers to have holistic understandings of how law serves societal goals. And I also really believe that if the arbitration community takes on a thoughtful consideration of some of these questions, that it will go far to restore the trust and the confidence in the sector, in arbitration as a mechanism, in dispute settlement as serving societal goals, and the role of counsel and arbitrators in achieving these global goals and beneficial outcomes for all stakeholders. I'll stop there.
Thank you, Lisa. Dennis, Nicolas, you want to add something?
And I have some thoughts, but I suspect that Nicolas' thoughts are much more valuable than mine, being really quite of an outsider to the arbitration field. But I think what Lisa, what you're saying also reminds me something of, I think links to something that Nicolas said, which is to me shows kind of like the structural problem with the current system. And Nicolas, you were saying some of the exceptions are not being applied. And I think that this is the problem, that the thing that is most important is the exception to the rule. And to me, that's the fundamental problem with the system. If we have a system that kind of like, seeks to serve society, then it should be to have more sustainable investment. And that should be the purpose of any mechanism, treaty or whatever that we then build upon. But I think that to me seems to be the fundamental problem, is that there are very narrow primary objectives that are not serving society at all, that are harming society at the moment, and that we're relying on the exception to be applied. But as we've seen in the last, I would almost say 30 years of economic regulation, the exception always loses. The exception is not applied, it always loses in practice. And if we don't make the exception the rule, and that is we need a livable planet to have a prosperous life, then the system is, I think, it won't work for us, but it will keep working against us.
Nicolas.
I have little to add. As concerns substantive international investment law, I fully agree. And I fully agree in particular, as you said, Dennis, that the positioning of the non-economic values as an exception is truly problematic. And that is, of course, the case in investment law. It is equally the case at the WTO, in international trade. So, and that basically is a consequence of the world order that has been built after the Second World War, which was entirely focused, which started from the erroneous assumption of a limitless world, right? And from the paramount objective of economic growth. And the problem with international law is that that has been locked in before international environmental law was developed. And therefore we have a problem that international economic law was there first. And given the stability focus that I mentioned in my introduction, it is very difficult to change that system. And I fully agree with you that there is a need to change that. And I also agree that that cannot be achieved under the current system, which is why I said that at least what we can achieve, and I believe that we can achieve it, and that is the most urgent matter under the current regime, is to make sure that investment law does no wrong. And again, and that is a challenge in itself. I fully agree.
I'll say a few words before I let a few questions, although not many, unfortunately. As I said before, I'm an arbitrator. That's a lawyer by training. I was counsel for a long time. I do essentially act as an international commercial arbitrator. That's my job. That's what I do. I'm not a politician. I'm not going to change any rules myself. I'm going to have to play as a citizen, as a father, and as a professional with what I have on hand, because also I think time is of the essence. And I personally do not believe much in the fact that international governance can be achieved easily. I think if something is achieved, it will be by way of imitation. Some country will do something right and others will imitate. But I think in light of the many diverging interests, in particular between the North and the South, it will be very, very difficult to achieve a level playing field with international governance, because I'm afraid we're really running out of time. So I believe more in imitation when a country does something good. I believe in what we have as an arbitrator. My position personally is that climate change will develop in arbitration, even in commercial arbitration, as a sort of a transnational public policy with, we've got this new EU Commission directive that's going to come forward with the obligations for companies to devise a plan to remain within 1.5. The SEC itself has published a draft rules last week to oblige companies if they make carbon neutrality statements to publish their scope 1, 2, and 3 plans in detail, which will bring a lot of pressure on those companies to actually act. It's far from being perfect, but there will be a lot of pressure. If you add the climate law for the EU, the systemic integration, the state court decisions that are issued in the Netherlands, for instance, the Netherlands, you sentence your own government, you sentence the big corporation, and the same in other countries. All of this will create, in my view, and I hope, a climate public policy that means that at some stage, in cases, if parties don't raise the issues, when they litigate their claims, arbitrators could raise those issues ex officio and have a debate on those. Because if this is not done, if you're talking about a non-exit award, it may just well be set aside at the place of arbitration, because at the end of the day, if it's an investment award which is a non-exit award, a public policy review may happen at the place of arbitration. If it's an exit award that benefits from a very strong enforcement and simplified enforcement system, at the end of the day, I think as temperatures rise, enforcement might always also be problematic if the issue of climate change was not properly addressed, because in a world at 3 degrees, I'm not really confident on the rule of law, no matter what the treaties are saying and what the enforcement mechanisms might be. And one of the ways to look at it sometimes, I think, is I think we should try to do our best, and this is something. Last year, there was this Vattenfall case that was settled by Germany about the phasing out of nuclear power. The way the debate was structured before the arbitral tribunal, it's very likely that if the case had not been settled and the award had been rendered, the award, because there was no debate on climate change issues between the parties regarding the phasing out of nuclear power in Germany, the award would not have contained a word about climate change, which I think could have been problematic in terms of the public policy that I see arising quickly, also because of state court pressure in the Netherlands. If the Netherlands is the place of arbitration, I think the issue is to be dealt with, and also in terms of social acceptance. If you have a country like Germany that is strongly anti-nuclear in the vast majority of its population, having an award that allows, gives damages, grants damages to the investor and not saying a word about climate change would be wrong in terms of social acceptance. And we had suggested with my friend Tom Aleman, we had written an article, and we believed in some kind of something like the Cellini test, but in a revised way, where you measure legitimate expectations, not taking into account science as well, and you could apply this to the investments as well as to the state measures when they change the rules of the game, and that we all have to look at the effect on climate change, the effect on biodiversity, because that's related. Do we have the relevant and accessible natural resources for the alternative policy? Does the measure protect human life and health? I think that those issues should be discussed in investment awards dealing with climate change before a decision is made, because I believe this will be part of public policy in some form. And I think as an arbitration practitioner, this is what I see. It may not be the solution for a lot of people, but again, I'm not a politician. And unfortunately, I don't really believe, and again, I'm sorry to repeat this, but in quick international governance changes. So I don't know if anyone in the panel has anything to say, and that way, and if not, you know, I'll give way to the questions. No. So it's going to be very short for the questions, but we had a question, practical question on the use of amicus curiae. When an arbitral tribunal refuses to grant leave to the communities affected, such as in the Odyssey versus Mexico case, to provide evidence in the environmental damages that the activities of the investor would cause, could it be argued that the arbitral tribunal is failing to consider relevant facts in relation to contributory fault or the investor and its duty to mitigate damages, which could in turn have potential implications in the enforceability of the award? Who wants to address this question? It's from Jessica Pineda in the chat.
Well, I find it a very interesting question. I think the answer would depend on the circumstances of the case. Technically, the amicus curiae is a non-disputing party. So the arguments it brings must not be answered by the tribunal. Then again, if it were to appear that there was a strong insistence on having a amicus curiae being heard, for example, one of the parties would also insist, that would not be done. And in addition, it would appear that the tribunal failed to properly address the issues the amicus curiae wanted to bring forward, then perhaps indirectly it might be an issue indeed, yes.
Question, I'll move on because we won't have time for many questions, but I like not to disappoint too much the people in the audience. Question from Thomas Lehmann for Lisa. Could terminating international investment agreements and triggering sunset clauses not be worse than trying to reform international investment agreements?
So yeah, I was trying to actively keep up with the discussion in chat. Great questions and great discussion. And Maxime helped to answer that question even before I did, which is that there are many ways to conceive of mutual, first of all, let me say that there are many ways to conceive of mutual termination that could eliminate the consequences of the sunset clause. Maxime pointed out that the the termination of intra-EU bits served as a model, and I shared a couple of resources where we look at this question in depth and also propose some language to UNCITRAL modeled off of the EU convention and other types of multilateral conventions that could help to neutralize the sunset clause. Even in the case of unilateral termination, is staying within such a costly system indefinitely because the costs of exit are high better than exiting and trying to work with your your treaty partners and or the rest of the world to resolve this sunset issue? I am still in favor of calling on the conscience and the good social sense of governments, treaty partners, and the international community when the justification for terminating is that we have looked at our treaties and they are not serving our objectives. In fact, they have cost us extraordinarily, or they are holding us back from critical legislation, or we are looking to other countries, similarly situated countries who are facing billions of dollars of claims, and we're realizing that we need to reform the system. I believe the international community will understand, and that if we shift the discussion, we can move to more support for those positions. So that would be what I would say on that.
Anyone? No, it's again, I'm for a moderator, I tend to speak a bit too much, I think, but I'll add to my misery. But I think one of the for me, like really the main priority for me would have to have everybody, including people in high school, last year of high school before entering university, have, and it's widely available, it's easy to find, a course on energy and climate change from the physics and chemistry perspectives, 30 hours, because that would change the way politicians operate, lawyers operate, economists operate, and you also see how difficult this is. I'll add another question for. I'll read the question in the chat. Thank you very much.
I had you prompted an idea on my side. As concerns education, I think there is a very important point, which I have made in certain circles unsuccessfully. I will not mention which one, but we have so many very prestigious Master complémentaire, Master 2 en arbitrage, LLM in international business law, LLM in international arbitration, where we educate arbitration and dispute settlement elites. I have made the argument once, and I would like to make it now officially, that one of the problems we have in raising awareness is that we educate people for dispute settlement of economic law and totally isolates them from human rights, environment, etc. So it is also, it starts with education, as you said, and it should be forbidden to organize an LLM in international arbitration without adding a course on climate change, as you said, and I've said before, business and human rights, for example. So I think that is a very important point, in particular for arbitration.
In my view, and I'll take one last question after this, I think when I referred back to the physics, and that's something that really resonated with me, and when I said that kids in high school before they enter university should have that class, it's actually looking at what happens physically, and in last year's presentation with Jean-Marc Jancovici that I referred to earlier, he had explained something that resonated with me very strongly when he said modern renewables, wind turbines, and solar panels are kits of globalization made by fossil fuels, and which means that you use a massive amount of fossil fuels through machines to do the mining, the extraction of the minerals, to build the equipment, to transport the equipment, and to install the equipment. And you realize all of this, even to build our modern renewable energies, it's nothing like the traditional windmills we had 300 years ago. And that's a tremendous challenge because we see even this still depends on fossil fuels. So what you see is the societal and political adaptation effort that is needed because the problem is so complicated. And I, unlike Lisa, I'm less optimistic on international governance, I said, but I certainly hope that that people take the science to task, the science to task, and say, this is what I'm going to do, and others will follow suit. But that's for another day. Yes, I'll take one last question, because then we have to go. Question for Nicolas. Can the wide discretion of tribunals in calculating damages be the root of the problem? Most international investment agreements do not provide specific rules on valuation, except for the case of expropriation. Should certain methods of valuation be prioritized in climate-related investment disputes to DCF or not to DCF, in light of the potential to grant compensation for speculative and unrealistic future profits? That's the question. And could tribunals strike a balance between competing interests to precisely allocate the financial burden of the energy transition at the stage of quantum by relying on proportionality analysis? Thank you in advance. That's from Nicolas Giannopoulos. Mike, you need your mic.
Thank you. That's a very nice question, and perhaps too technical one to answer here. So I've noted the question and will perhaps contact the author in parallel. I would say, just at a fundamental level, the amounts claimed and often awarded, therefore the calculation methods, are probably core to the problem of international investment arbitration that is mentioned by Dennis and by Lisa, in the sense that it is the enormity of amounts that causes enterprises and lawyers to go for the best, because they hope to hit the jackpot. A number of years ago, I wrote an article on specifically that issue, arguing that one should replace compensation with restitution to moderate the appetite of the actors. And I think that in many investor arbitration cases, that could help. If something has been done wrong, well, we give it back to you and you can continue your business. However, unfortunately, that does not work for climate change, because there we have regulatory measures which specifically aim at halting some kinds of activities. And of course, Dennis will agree, if Uniper were to win the case, there would be no point in saying, okay, well then here is restitution and we give you your coal plant back. So that is not a solution, but I do agree that we have to find a means in international investment law to moderate the disproportionate impact that damages may, in my view, have on the behavior of some actors.
So can I just jump in quickly on this? I also noted in the chat, but I think this question around compensation and appropriate principles for compensation for the phase out of fossil fuels is a critically important question, not only in the context of ISDS, but for domestic law, for other aspects of international law, and so on. We're dabbling in this with a webinar that I linked to in the comments in a couple of weeks, where we will look at how tribunals have dealt with this, but also to discuss what principles might usefully apply in thinking about the apportionment of responsibilities and costs in the energy transition.
Thank you. I'm afraid that we're not going to have time to answer other questions. We're slightly exceeded by 2 minutes, 7 p.m. in Paris. I think it's okay with Zoom. It's still recording, even if we've been beyond the limit. I want to thank the three of you. It was a very enlightening discussion. We know where the differences are, and I think we're all actors of good faith, trying to do their best in their respective and different fields to cope with the problem. I'm very sorry not to take on any additional questions. Just for tomorrow, I want to add that I have another webinar at 3 p.m. Paris time on the proposed directive of the European Commission on corporate sustainability due diligence, that deals with how companies will have to deal with issues of human rights and climate change in their global supply chains. And tomorrow I have we'll be very lucky to have Noëlle Lenoir, who was the first ever female woman on the French Constitutional Court in France, and she was also, by the way, and still is still remains the youngest member of the French Constitutional Court, and she was also a minister of foreign affairs, and she has a deep expertise in those compliance matters, so she'll be commenting on that tomorrow. So for those of you who may be interested, you can still sign up, and maybe I'll see you tomorrow at 3 p.m. In the meantime, thank you again to all of those who are in attendance. Thank you, Lisa. Thank you, Nicolas. Thank you, Dennis. Good morning or good afternoon, wherever you may be. Thank you. Bye.
Thank you very much.
Thank you. Bye-bye.
Goodbye.